Good morning, everyone. I'm calling to order this public hearing of the Committee on Judiciary and Public Safety. I'm Councilmember Brooke Pinto, representing Ward 2 and Chairwoman of the committee. The time is 9:34 a.m. on Monday, February 3rd, 2025. We are conducting this public hearing in person in room 500 of the John A. Wilson Building and virtually via Zoom. We're also streaming on the DC Council website and on YouTube and X at @CM Brooke Pinto. The Committee on the Judiciary and Public Safety has oversight responsibility for matters affecting the district courts, criminal law, procedure and justice, public safety, including policing, violence prevention and intervention, and civilian police oversight, access to justice, including victim services and justice grants, fire and emergency medical services in the district's 911 and 311 services, forensic science, fatality review, medical examinations, Homeland Security and Emergency Response, Adult Corrections, Family Law, Probate and Estates, Child Support, and Women's and Gender Policy. Today, the committee is meeting to conduct a performance oversight hearing for the following two agencies. First, the DC Sentencing Commission, and second, the Criminal Code Reform Commission. We will begin with the DC Sentencing Commission. The commission was created in 2006 for the purpose of producing voluntary sentencing guidelines for judges in the District of Columbia in order to ensure greater consistency and fairness in sentencing. The Sentencing Commission is also broadly responsible for analyzing sentencing data, policies, and practices, both in the district and across jurisdictions. This includes tracking case-by-case sentencing and compliance with the sentencing guidelines. The Commission produces recommendations to the courts, the council, and executive agencies on enhancing the fairness and effectiveness of criminal sentencing in the district. The commission is composed of 15 voting members and 5 non-voting members, although there are currently 3 vacant seats. The Secure DC Omnibus Bill increased the commission's voting membership by 12 to 15 by adding 1 mayoral nominee, subject to council approval, 1 council appointee, and the chief of police as voting members. The act also modified the bar member requirements. Instead of having 1 member who specializes in criminal defense and 1 who does not specialize in criminal law, the commission will now include 1 member with criminal defense experience and 1 with prosecution experience. Additionally, Secure DC required 1 of the council appointees to be a returning citizen and adds the deputy mayor for public safety and justice as a non-voting member. These changes were made to ensure the commission includes perspectives from all parts of the criminal justice system. While the sentencing guidelines are voluntary, judges do adhere to the guidelines almost 99% of the time. And so it's important to have a conversation today about these guidelines and some of the factors that go into making these recommendations, especially with some new offenses that have been added this year. Next, we will hear from the Criminal Code Reform Commission, also known as the CCRC. The commission was established as an independent agency with the purpose of providing recommendations to the council on comprehensively revising our criminal code. The commission was originally planned as a temporary agency, but the council subsequently converted it into a permanent entity tasked with continuing to provide expertise and guidance on changes to criminal laws in the district. Today, we are joined by my colleague at-large Councilmember Christina Henderson. We'll turn to you, Councilmember Henderson, if you have any opening statement.
I don't have an opening statement, Councilmember Pinto. Thank you.
Okay, great. In that case, we will turn to our public witnesses. We have 1 public witness who signed up to testify regarding the Sentencing Commissioner Ashley Ruff, ANC 7F02. Commissioner Ruff, are you here? I don't see you, so if you'd still like to submit your written testimony for the record, please email it to my team. All right, we will now call our first government witnesses for the Sentencing Commission. Lyndon Fry, the director of the DC Sentencing Commission, and the Honorable Dana Dason, Associate Judge of the Superior Court of the District of Columbia. Director Fry, are you here?
Good morning.
Good morning. As you both know, it is the tradition of this committee to swear in all government witnesses who appear before it. If I can ask you both to take yourself off mute and raise your right hand. Do you swear or affirm under penalty of law that the testimony you're about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
I do.
I do.
Thank you very much. All right, I'd now like to invite our government witnesses to make any opening statement you may have. You can start with you, Director Fry.
Good morning. Thank you, Chairwoman Pinto. My name is Lyndon Fry. I'm the Executive Director of the DC Sentencing Commission, and I very much appreciate the opportunity to speak with the committee this morning. I'm accompanied by the Commission's Chairperson, Superior Court Judge Danya Dason. Judge Dason was unanimously elected Commission Chairperson last October following the resignation of Judge Lee. Judge Lee resigned after he became the Chief Judge of the Superior Court. Judge Dason is only the third commission chairperson in the agency's 20-year history. As you're aware and spoke of earlier, after the passage of Secure DC last year, the Sentencing Commission's membership increased to 20 members with 15 voting members and 5 non-voting members. Following the changes, the commission remains an apolitical, data-driven body with members who bring a diversity of expertise, experience, and views. I'm pleased to report I really do think in the Sentencing Commission's current structure that we have exactly the right positions at the table. Obviously, we would like to have all of the vacancies filled, and I think once that happens, we really will have all the viewpoints we need to make proper decisions. It's the Commission's longstanding policy, which has continued under Judge Dason's leadership, to ensure that every member, both voting and non-voting, is invited to participate in the drafting of guidelines and sentencing policy changes, and that they have the opportunity to fully express their views to the Commission prior to any vote. This ensures that all of the members' opinions on any matter are discussed and taken into account. Additionally, whenever possible, the Commission has tried to act with the consensus of all of its members. And by allowing all of our members the time to express their opinions on the matters, we've been able to accomplish that almost always. In fact, over the past 5 years, the Commission has only had 2 substantive votes that were not unanimous. So while we have a great diversity of opinion, the Commission has been very good at coming together and producing good law and good guidelines. Last year, following the passage of Secure DC, the Commission ranked 22 new or modified felony offenses or offense enhancements that were part of the legislated package. Using Secure DC as an example, I want to highlight one aspect of the Commission's ranking process. The Commission began by analyzing each new offense created by Secure DC and considered the offense's default ranking. Every new offense has a default ranking based solely on the statutory maximum penalty set for the offense by the council. The default ranking applies until the Commission reviews and ranks the offense. Additionally, the default ranking is used as a starting point for Commission ranking decisions. This is done because the Commission considers the default rankings as a good indicator of how serious the council determined the criminalized conduct is. Put more concisely, the Commission uses each new offense's statutory maximum punishment as guidance from the council on how to rank the offense. Today, I'd like to speak with the committee about 3 things: 2024 sentencing trends, so a little data from last year. This is some of the data we publish in our annual report that comes out at the end of April, but since we have some of it now, I want to share it with you. Talk about a few of the agency's accomplishments last year and some of the challenges facing the agency. So in 2024, the number of felony counts, cases, and offenders sentenced in Superior Court increased compared to previous years. The total number of counts sentenced increased by 50%, while the number of cases and individuals sentenced increased by 47%. So that's a fairly dramatic increase. Last year's sentencing figures are also increases over 2019, which is the last year we have pre-pandemic data for. Case dispositions, that is how cases are resolved or end up going to sentencing. Last year, 92% of all sentencing were the result of plea agreements. This is a similar rate to 2023, although it's a decrease from during the pandemic. So currently, like last year, we're seeing the same or roughly the same amount of jury trials and pleas as we have from before the pandemic. During the pandemic, obviously, there were a lot more pleas and fewer jury trials. One aspect of case dispositions that the Commission continues to closely monitor is the utilization of Rule 11C1C pleas. Rule 11C1C pleas are where the parties reach an agreement on a specific sentence or sentencing range prior to sentencing. And if the court accepts that, it's then bound to sentence the defendant to that specific sentence or within that agreed upon range. We've actually seen a fairly significant decrease in the court's use of 11C1C pleas. Only 6.2% of all felony cases sentenced in 2024 followed from a Rule 11C1C plea. That's a 25% decrease from 2023 and a 40% decrease from 2022. So the Commission's still going to continue to observe and analyze that to see if we can make any conclusions from that data. We don't have any yet. Right now, we've only just seen the decrease, so I don't yet have a why that's happening. At the case level, prison sentences still remain the most common sentence imposed for felony offenses. 61% of felony cases, 62% of felony cases received a prison sentence in 2024, which is different from the approximately 61% that did in 2023. The Commission observed an increase in the percent of counts sentenced from felony drug offenses. This has been something we've been looking a lot over the previous years because the number of felony drug sentences had decreased. As you may recall, only 69 felony drug offenses were sentenced in 2023, constituting just 4.7% of all sentence imposed, which was the lowest drug offense sentencing rate we'd ever observed. In 2024, the court sentenced 209 defendants to felony drug counts, which brought it up to 9.4% of all counts sentenced. And this was the first increase in the percentage of drug cases we've seen since 2017, when drug counts made up 25% of all felony counts sentenced. The number of felony weapon and violent offenses sentenced in 2024 also increased. The court sentenced defendants in 877 weapons offenses and 644 violent offenses. That's up from 628 and 440 respectively in 2023. However, due to the overall increase in felony count sentences, the percentage of weapons and violent counts remained approximately the same as 2023. As you mentioned at the beginning, compliance with the voluntary sentencing guidelines remains very high. Last year, 98.4% of all felony count sentence complied with the guidelines, and overall guidelines compliance has remained over 97% for the last 7 years. Importantly, 95.5% of counts sentenced were within the guidelines recommended sentencing range and options. And so what that means is that there are ways that judges can impose sentences that comply with the guidelines, but are still outside of the box. But what that figure means is that 95.5% of sentences were actually within the recommended range and sentencing options for that defendant for that offense. And that rate's the highest the Commission has ever observed. Of the limited number of cases sentenced outside the guidelines, the recommended sentencing range or sentencing options, the majority were less severe than the guidelines recommendation. While the Commission is satisfied with these compliance rates, the goal is not to achieve 100% compliance because there will always be exceptional circumstances that require a sentence outside of the guidelines. I also want to talk for a minute about arrest sentencing data. And so as you may recall from years previously, the commission tracks cases from arrest all the way through sentencing. Part of that is looking at case papering rates, so whether or not prosecutors bring a court case following an arrest. In 2024, the number of adult felony arrests made in the district increased by 2%. However, the overall felony case papering rate increased by 66%, from 66% in 2023 to 72% in 2024. So that means that 72% of felony arrests resulted in the filing of a case in Superior Court. And the 72% papering rate exactly matches 2018, which is the greatest rate we've observed since the commission has begun monitoring these trends. One piece of interagency data I also want to share has to do with our data and data requests. As you know, the commission has continually received more and more requests for sentencing and criminal justice data. In FY23, the commission responded to 11 data requests. In FY24, that number increased to 29, and we've already responded to 5 requests in FY25. And FY25. Staff has been able to accommodate these requests. However, at times it has to prioritize requests from agency partners over other requests. Additionally, if the workload continues to increase in the near future, we may not be able to respond to every request we receive. Now, a couple of agency accomplishments, and I know I highlighted these in my written testimony and the performance question, but there's 2 I do want to mention. The first is an agency reorganization. So to add more resources to our data team, the commission conducted a restructuring where we now divided the commission into 3 teams. We have a data research team, a legal and sentencing policy team, and then a general support team. And this is now headed by the research director, who's our former statistician, Taylor Tarnalicki, who is an incredible resource for the commission. And the legal and sentencing policy team is now led by our general counsel, Megan Buckley. And so this new structure is being used so that we can put more resources into our data work and streamline agency efficiency. The other accomplishment I want to mention is that we are finalizing the process of doing a complete restructuring of the voluntary sentencing guidelines. The guidelines are over 20 years old and have never been restructured. And by restructured, I don't mean making substantive changes to the guidelines. This is a top to bottom reorganization. So we went through every single word, example, hypo, rule in the guidelines, and restructured and reorganized them so that they were clearer, consistent, easy to follow, and that someone who's less familiar with the guidelines can pick up the guidelines manual and really, in an easy order, have a good idea about how the guidelines work and how they're applied in court. This has been a tremendous effort because it was not intended to be a substantive change. We spent a lot of time making sure that the rules themselves stayed the same, even though the new structure was helpful. Staff spent over 1,000 hours on this project, and I have to give a lot of credit to the Commission's Guideline Implementation Committee as well, who met for over 24 hours in addition to reading hundreds of pages. And like I said, doing a word for word review to make sure we have the best product possible. I also want to give thanks to our general counsel, Megan Buckley, who has led this project. So those are 2 of our bigger accomplishments. We also have 2 challenges that I want to mention. Neither of these should be new to this committee. I spoke about them both last year. The first is accessing data after the Superior Court implements its new case management system. As you probably remember, Superior Court is in the process of upgrading its case management system. This has been an arduous and difficult process for the Superior Court, and it goes well beyond the interactions with the Sentencing Commission or data partners. It affects many, many aspects. We're just one part of this. But how it affects the Sentencing Commission is the Superior Court's data is changing. It hasn't been fully finalized yet, but that structure is changing. We will need to modify our own in-house data system so that we can continue to receive and analyze data after the court implements those changes. However, the delays and then because it's not finalized yet, the Sentencing Commission can't tell you exactly the scope or timeline of when that work will need to be done or what it will entail. And so we will continue to remain in contact with this committee as well as the executive as we go forward this. We do have a very good relationship with the Superior Court in this program, which is with the help of the Criminal Justice Coordinating Commission. We meet just about every single week to talk about enterprise justice and the changes that's going to happen. So I think the court has been a very good partner in this. It's just been frustrating for everyone all the way around. The second issue is that the Sentencing Commission does not have access to pre-sentence report data. So we can paint a picture of what sentencing looks like today in the district, but what we are unable to do is actually go back and look at defendants' prior criminal records to see how they ended up here. So CSOSA produces a pre-sentence report for the court for just about every single felony defendant sentenced. That includes all of the defendants or all that they can find of the defendant's contacts with law enforcement, from arrests as well as convictions, juvenile, anything that they can find. And it's a wealth of data, and judges and the parties use that to prepare for sentencing. However, the Sentencing Commission doesn't have access to it. So that means we can't go back and look at, what happened to, defendants being sentenced for robbery. What do their criminal histories look like? Or in the alternative, if we were to change this part of the rules on how to calculate criminal history score, how many defendants would that impact? Would that give people higher sentencing recommendations? Would it give them lower recommendations? That type of analysis we can't do. And so the commission continues to try and pursue getting access to pre-sentence report data. So with that, I'm happy to answer any questions you might have.
Thank you very much, Director Fry. And Judge Jason, am I correct that you don't have an opening statement, right? You're just here for questions?
I do not. I am deferring to Director Fry, who has a wealth of information, but I'm happy to answer any questions that you may have for me as the chairperson.
Okay, fantastic. Thank you both. So Director Fry, how many new offenses were established in the past year, and what has the Sentencing Commission designated them as in terms of class?
So last year, there were 22 new offenses or new offense enhancements that we ranked, and those came out of the Secure DC legislation. One thing the commission has been able to do recently, which is different than the past, is we actually start looking at offenses while the council is looking at them. And so we start gathering information. So even before statutes become enacted, we can start briefing our members and getting ready for votes so that we can get offenses ranked more quickly than in the past. Previously, we'd wait until we actually started seeing offenses being sentenced before we rank them. But so last year, the answer is 22.
Okay, and of those 22 offenses, how many of them were categorized as eligible for split sentences?
That depends on the defendant's criminal history score. But for defendants with the lowest criminal history score, so that would be defendants who fall in groups 6, 7, 8, and 9 are eligible for split sentences. And
Okay.
Ms. Buckley, if I can, don't go anywhere without my grid.
All right, that's right, I was gonna say.
So what we're seeing is group 6, 7, 8, and 9 are eligible for short splits. In group 6, only defendants with the least severe criminal history score are eligible for a short split sentence. As the severity of the offenses decrease, defendants with more criminal history score become eligible for those offenses. Yeah, a prison sentence available in every single box, regardless of where they are. I believe, I'm quickly looking through our ranking memo. I believe every offense that came out of Secure DC was ranked in group 6, 6 or lower. I know we have several in group 6. We have a majority of them in master group 8. I don't believe any of them were in M5 or above.
Okay, so when you say lower, you mean a higher number?
Sorry, I mean a less severe ranking. So yes, a higher number, that's right.
Okay, so which of the offenses were categorized as group 9?
One moment.
Okay.
Okay, thank you. So unlawful discharge of a weapon was the only offense categorized in M9. The vast majority were in M8. Strangulation while armed was ranked in master group 6.
Okay. So one of our intentions with establishing a new offense for unlawful discharge of firearm was that we had seen several cases where individuals were kind of shooting a weapon into a public space. And even though they might not have hit somebody, they could have. And under this recognition that this really needs to be its own standalone felony offense. And so that one is of concern to me, to be ranked so low. What were some of the factors that went into that decision to suggest that that should be on par with receiving stolen property, or something that is less violent in nature and therefore more likely to receive the group 9 designation?
I apologize. I'm just pulling up my notes so I can give you an
Sure,
accurate
yeah.
answer. So the primary factor for unlawful discharge of a firearm, the reason why it received that ranking, was because it has a statutory maximum of no more than 2 years. So taking into account backup time that has to be reserved for supervised release, Master Group 9 was really the only box on the grid that allowed for legal sentences that fell within the guideline ranges. Otherwise, if we'd ranked it higher than that, most of the options on the grid would not have been available, because the judges to impose a legal sentence would not be able to impose a guidelines compliant sentence.
Got it. Okay. Thank you for that.
I hope that makes sense. I
Yeah,
can
no,
explain it
that's
more.
helpful. So tell me about the probationary period that is weighed against the maximum statutory time.
So there's three ways defendants are put on supervision, but the two primary ways are, the judge can suspend all or part of the sentence and put a defendant on probation. That's one way. Or if the judge doesn't suspend any of the sentence, following release, the defendant is put on supervised release. And that supervised release is handled by the U.S. Parole Commission. If their supervised release is revoked, then there's backup time that can be imposed against that defendant. Because of that, for all but Class A felonies, that backup time gets subtracted from the statutory maximum for the maximum sentence the judge can impose at sentencing. So for example, if you had an offense with a 10-year maximum penalty, but 2 years of backup time, the highest legal sentence the judge could impose at sentencing would be 8 years because they have to subtract the backup time.
Interesting. And is that common for all jurisdictions that you're aware of with sentencing guidelines, that the backup time is happens after the calculation for the maximum, so that it's really taken against that time?
I haven't done that research directly, so I don't want to speculate on if that's common or not. What I can
That's
say,
always how it's been kind of done in the district.
yeah. And I mean, the one exception to that is for Class A felonies, which you could think of as the most severe offenses. For those offenses, the backup time is not subtracted out. So if the statutory maximum is 30 years, the judge can impose straight 30 years. It's all the non-Class A felonies where you do have to subtract the backup time. And that's not an aspect of the sentencing guidelines, that's an aspect of the code.
Right, got it, okay. And I know there are a number of offenses, so it could be kind of a generalized response, but is it your understanding that most of our firearms related offenses have statutory maximums?
Every single offense has a statutory maximum.
Okay. And the 2-year maximum, I imagine, was kind of in line with what some of the other related offenses were.
Yes. Yes.
Unlawful charge.
And like I said, it's certainly not the only thing the Sentencing Commission considers, but the statutory maximum set by the council is one of the major elements that the commission does consider when it first starts looking at how to rank an offense, because we'll look at, what's the default ranking, what are other offenses with the same statutory maximum, how have we ranked those? Then we'll look at what are other similar offenses, how have we ranked similar offenses to that offense. For offenses that can be committed in different ways, we try and look at what are all the different ways that offense can be committed. Are some of those more or less severe? We look at, what's the potential harm to victims, what's the harm to society. So there are a number of things the Sentencing Commission considers, but we almost always, and again, I'm not a commission member myself, so I don't want to speak for the commission, but historically has started by looking at what's the maximum penalty that the council set for this offense. Because it really does serve as this is an indication of how serious the council feels this offense is.
Okay, thank you very much. So you spoke in your testimony about some of the barriers that you all have with access to data, and some of the challenges associated with that. Are there any ways that the Sentencing Commission is working this year to try to secure access to more of that data, to have more fulsome analysis, or is that something that you need additional technology or staffing to accommodate?
Well, it's a combination of both. One is just being able to access the data that our partners already have that's provided to us and making sure we can continue to do that. And that's a technology hurdle that we continually encounter. Our data system is approximately 10 years old. It still functions well, but it's showing its age. And we will begin in the next couple of years kind of looking at what's the most efficient option. Is it doing a major system upgrade? Is it replacing the system? However, I will tell you that we haven't begun that because we're waiting to see how enterprise justice works out with the court. We don't want to get ahead of it and put ourselves in a bad situation, as well as, we do know that we'll need to move to the cloud in the future or restructure our servers just because based on the volume and the types of data we handle. And so it's keeping our system up to date. Then there's the actual doing the data analysis, which, the amount and complexity of analysis we've done continues to increase. And so that's put a lot of pressure on our staff. And I'm incredibly fortunate. I have an excellent staff. They're very good at their jobs and they work very hard. But at some point, there's just a limit on how much they can do with the resources available. And then the biggest impediment, at least what I talked about before, is really the data that we receive. And so without access to pre-sentence or criminal history records, there's just a lot of analysis that we're unable to complete. In the future year, we have a new chief judge with Superior Court that we look forward to working with on this issue. As you might recall, CJCC has also been addressing the issue of how to get district agencies data with exceptions to the Privacy Act, both from CSOSA and other agencies. And so we very much hope to consider, to keep working with the CJCC principals on that to see if we can find a way to get that data either from CSOSA or another place. Or the alternative, which is not something we've looked into a lot, but may be the answer in the future, is whether or not we need to ask for a change or an amendment to the Privacy Act that would, specifically say that, pre-sentence report records can be given to the DC Sentencing Commission, but that would require a change in federal legislation.
Thank you. And thank you for mentioning that, because I agree that that's going to be an important conversation that we need to have this year with our federal partners, because it continues to be a large hurdle with the Privacy Act. So thank you. In terms of the enterprise justice transition, were there any, I know there have been some issues with phase one. Have there been any kind of lessons learned through that process that will inform the strategy going forward with the phase two of that transition?
Because phase one doesn't involve criminal data, I'm going to see if Judge Dason has any opinions on that. I unfortunately couldn't answer that question.
Yes. So I think while I'm not involved in the IT steering committee, which is really the committee that is dealing with that, I did serve in one of the divisions that had a phase one launch for enterprise justice. I think one thing that we learned was that we have to do a lot of testing before we go live. I think there was a lot that was done, but I think there were perhaps what we learned was that there was a lot more testing that needed to be done before go live, certainly for phase two. I will just say that with respect to the date for phase two, I do not think that we have a date for phase two. I know that I've heard some people say fall of 2025. To be completely transparent, I don't think that that's a date that we have right now.
Okay. Are there, how do I say this? How will we know when the next phase is going to begin? Like, what are the hurdles to getting that information?
Do you mean what kind of benchmarks is the IT staff here setting? Is that the question?
Well, I just mean, if we don't know when we're going to be moving to phase two now, how will we know? What are we waiting on?
So I mean, I can certainly circle back to try to get some information from IT as to what sorts of milestones they are setting for themselves, as far as, I don't think it's a temporal milestone as much as a operational and functional milestone. Given the divisions that are involved in phase two, nobody really wants to have that be a work in progress as it's alive. But I can certainly circle back and ask them what sort of functional milestones they're looking at. I will say that we are committed to keeping our partners updated with as much lead time as we can possibly give them. But as I said, I just don't think these are temporal milestones as much as functional ones.
Okay,
And
thanks.
if I could piggyback on something
Sure.
Judge Dason said, just because I want to be very clear about this, this has been an incredibly frustrating process, but the court has gone out of its way to try and support its partners as best it can. This isn't like we're being ignored or put in the corner. Like I said, the court sits down and meets with CJCC partners about data and talks of this project almost every single week, and really does try to keep us on board. It's more of an overall struggle with the project in general than anyone making anyone's life more difficult than it has to be.
I got you. And I don't mean to suggest any differently than that. I just want to get a sense of if there's anything else we can be doing to support the mission of the transition.
Of
But
course.
thank you.
I'd like those answers too.
So I want to give the commission kudos for all of your efforts to engage the community over the last year. I understand there's been over 180 different community engagement events and interactions. Can you speak a little bit about how some of those have gone and how they've informed the commission's work?
I think that's a great question. So the events have gone incredibly well. I think this is not something the Sentencing Commission historically did a lot of, is going out in the community. But over the past several years, led by our outreach specialist, Brittany Bunch, who teaches all of us every single day on outreach things, to really go out there and interact with community members and hear their comments. And it's been very powerful. I certainly won't say I've been to all of these, but I go to a number of them, and just speaking with individuals, it really does give us viewpoints that we can bring back to the commission. And as I'm sure you've heard, those viewpoints, while very dramatically, from people being like, this is wrong, you shouldn't be locking anyone up, you're taking people out of the community, that's terrible, to the sentencing guidelines are so much less severe than they should be, we need harsher punishments. So we hear a broad variety of comments, but you really do get the feel in talking with people and being in the community of, what's driving those comments, what are their concerns. And so we bring them up to the commission, although one of our goals for 2025 and into 2026 is actually developing a more formal mechanism that we can, at least on an annual or semi-annual basis, present these comments to the commission so they can all be seen. What are we hearing on the street? Rather than kind of piecemeal as issues come up, here's what we've heard, but more, generally, this is what we're hearing, and have those discussions, because I think they are very telling. We're interacting with the people who are experiencing, what it's like to be a victim, or what it's like to have a family member incarcerated or have been incarcerated. We get viewpoints from returned citizens all the time, and their views vary just as much as anyone else. Some of them think it should be more stringent, some of them think it should be less. But just about everyone I've talked to leaves an impression on me and the staff, and we try to relay that to the commission. So I think it's been very powerful and very effective.
Thank you very much. Thanks for your commitment to that piece. I agree. It's very important to hear directly from people, and even in the midst of a wide range of reviews, kind of helps get a sense of where an appropriate place may be. You mentioned some of the technical limitations in video production and social media capabilities. Is that something that you're working on expanding this year?
It is. We're constantly, we run a very lean operation. We're fortunate to have the staff and the budget we do, but obviously more would be better, but we understand exactly the situation that all agencies are in. So within those limitations, though, we're constantly trying to upgrade our technology to make for better video or production materials. And I will say it's a small thing, but it's helped a lot. Most of our computer systems are PCs, but we actually have, for video and social media production, we have some Apple products that have also kind of made that a little easier and increased our production values.
Okay, and I hear you on the budget. I mean, we'll get into that probably in a couple of weeks, but are there kind of specific budget enhancements that you are looking towards this year?
The biggest budget enhancement we're looking for this year is transitioning our server either to, well, we evaluated transitioning it to new physical servers with Octo or into the cloud. And we determined that it was the most efficient and economical to transition into the cloud. But there are costs, both one-time and ongoing with that. But that would give us a lot more both flexibility, system stability and system security. So that's one thing we very much would like to do, but that will take a budget enhancement.
Do you have an estimate about how much that would cost?
One moment, please. Approximately $650,000.
Thank you. Judge Dason, I'm curious from your perspective, as we talk a lot about how the sentencing guidelines are voluntary, but that in practice, they're almost always followed. Can you give us a sense from judges' perspectives on how things are going with split sentences in particular, and kind of what some of the points of analysis are when an offense is eligible for a split sentence, what some of the other kind of metrics of considerations are before giving a final sentence?
Sure. I mean, I think that obviously one of the things that's really important to take into account is that we, as judges, obviously we do look to the voluntary guidelines. And I think because of the way in which they are reached largely by consensus, there is a lot of faith in those and a lot of fidelity to those. However, each judge is aware that it's really incumbent upon us to look at each individual sentencing in a particularized way. I certainly think that some of the things that folks will look at is whether or not, based on an individual defendant's history, there are services that are best delivered in the community that folks think will be helpful in rehabilitation and therefore in the long term for community safety. I mean, certainly there are lots of services that are given in carceral settings, but there are some, frankly, that are best delivered in the community. I think a lot of judges will look at that as one of the things, which is just how does this transition have a more successful end? And for us, successful ends, I think, are a lack of reoffending. And so I think that's one thing that is quite important for judges. Certainly, I don't want to speak for all of my colleagues, and I'm speaking as the chairperson of the Sentencing Commission, and certainly not on behalf of all of Superior Court, but to the extent that I'm bringing my own perspective as a judicial officer, that's certainly one thing that I look at.
Okay, thank you. And to what extent does that perspective come into the conversations with the promulgation of new guidelines, especially when there are new offenses being considered?
So again, I think the starting point, as Director Fry has indicated, really is the statutory framework for this. And so I think that's more of a driving point. I will say that because I was not part of the Sentencing Commission when Secure DC was reviewed, I'm not sure how much it came up, rather than sort of hypothetically how much it would come up in the future. I can defer to Director Fry on that, but it certainly does seem to me that would be part of the conversation. Although, again, I think we start with the statutory framework for sure.
And I can tell you what sentences might be eligible under a specific ranking definitely comes into the conversation for just about every single offense that we've ranked.
Sorry, say that again. I didn't follow.
So it's absolutely one of the factors that's considered when the commission is ranking offenses is what types of sentences would be eligible for that offense, depending on where it's ranked. So for example, if the commission were debating ranking an offense between M5, which is a prison-only box, versus M6, where defendants with the none or the least severe criminal history scores might be eligible for a short split sentence, whether or not it would be appropriate for someone to receive a split sentence for that offense is definitely something the commission discusses.
I will say though, back to your point as to how much of a that plays into the guidelines, while I wasn't part of that conversation, I will say that that is the type of particularized analysis that I think is probably more on a case by case basis rather than necessarily a systemic one. And the reality is that all of these have prison eligible offenses. So it's not necessarily saying that when something is ranked as a split sentence eligible, it is not divesting the judicial officer of the ability to look at an individual case and say, this is not something that I think is appropriate for a split sentence or not.
I see. Okay. Thank you both. In terms of some of the CSOSA data challenges, are there other jurisdictions that have been able to kind of get around that? Is it because our bifurcated system with the federal government that makes us unique, or are there other ways that we can use the lessons from other jurisdictions to try to have more access to this data sharing about previous criminal offenses?
It's a very unique issue for DC because just about everywhere else it would be done on the state level. So that's state data sharing. I can tell you most sentencing commissions do have access to this data, but they don't run into this, the problem we have, us being a DC agency and trying to get data from a federal agency. In fact, there is statutory law, not directed at CSOSA, but directed at the DOJ that allows the Department of Justice to share sentencing information with state sentencing commissions. But again, our sentencing data is collected and held by CSOSA.
Got it. Okay. Thank you so much. Let's definitely work together on that in the coming months. Okay, well, that concludes my questions for you both. As always, I want to give you a chance if you have any other things you want to mention for the record that we didn't get a chance to talk about, or any other closing thoughts. I'll start with you, Judge Dason.
No, I just want, I guess the only closing thought that I would have is I have, as I think Director Fry pointed out, I rejoined the commission in October, so I haven't had a whole lot of meetings with them, but I have worked, I have been a member of the commission in the past. I continue to just, I'm very honored to now be the chairperson. I continue to be incredibly impressed and with the work of the commission, especially their dedication to really working on data-driven solutions, the amount of effort that goes into really looking at data and the resistance to drawing conclusions ahead of data is I think quite remarkable. And I continue to I continue to be impressed with the work that they have done. Thank you.
And thank you for rejoining.
The commission is very, very fortunate to have Judge Dason as our next chair. I'd just like to finish by thanking this committee has been very good at supporting the work of the commission. Like I said, we run a very lean agency, and so we do end up making a lot of requests for resources because anytime we have to expand anything, it's not like we have a reservoir we can fall back upon. Most of our funding goes to either PS related or staffing related issues or to support the work of our data system. There's very little funding left over after that, which is why you do hear us asking for funds on at least a semi-regular basis. And I just want to stress that we don't do that lightly, but we do try to ask for just what we need. But we are very, very appreciative of the assistance that this committee has given us, and also just giving us the opportunity to present both of our data and let people know what the Sentencing Commission is doing and working on. So thank you.
Thank you very much, Director Fry. Thank you both. Thank you.
Thank you. Oh, actually, may I say one more thing?
Sure.
That I forgot because I didn't write it in my notes. The Sentencing Commission is most known for its grid. I had my big grid before. I actually don't even know if I'm on camera, but I have a smaller grid right now. The way the grid appears is one of the things that we've proposed changing in our restructuring of the guideline manual. It'll still be a grid. The offenses are still staying in the same place. It's just the coloring and the layout is going to look a little different. So this is what it will look like. You may not be able to see it, but I've left a copy with your staff, and I'll leave extra copies in case any other committee members would like to see that.
Great. Thank you so much. Thank you for mentioning that. I'd like to take a look at that. Okay. Thank you both. That concludes the part of the hearing today regarding the Sentencing Commission. We're now going to move to our second agency for today, the Criminal Code Reform Commission. We have no public witnesses signed up to testify on the CCRC, so I will call our government witness, Janu Park, Executive Director of the Criminal Code Reform Commission. Director Park will give you a minute to join, be promoted as a panelist. Hi, Director Park.
Morning, council member.
Morning, nice to see you.
You as well.
As you know, it's the tradition of this committee to swear in all government witnesses who appear before it. So if I can ask you to raise your right hand, keep yourself off mute. Do you swear or affirm under penalty of law that the testimony you're about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
I do.
Great. Thank you very much. I'd now like to invite you to make an opening statement you may have.
Sure. Well, good morning, Chairman Pinto, and thanks for holding this oversight hearing on the DC CCRC. So of course, I'm Janu Park, the agency's director. And let's talk about the type of work that we did over the past year since our last oversight hearing. Our work really falls in sort of three general categories. So first, we've conducted significant research and data analysis projects that were really intended to address criticisms that arose against the RCCA that were really related to the penalty provisions in that act. Second, we've continued revising offenses and have submitted recommendations for code reform to this committee. And then third, we've just continued to provide some testimony and feedback to the council on pending pieces of legislation. And I can discuss each of these categories of work in turn. Just also want to know, I did submit written remarks as well as an extra copy of our FY24 annual report to this committee at the end of last week. And those documents will provide much greater detail, fleshing out a lot of the projects that I'll discuss here. So you and your staff can have that on record. But first, talk about projects related to our CCA critiques. So although I recognize that passage of a complete RCCA could be challenging this time just due to the national political climate, we're still really, really committed to our mission of code revision, even if that effort ultimately takes a lot longer than we would have liked, or needs to proceed in a more piecemeal manner. So to this end, the CCRC finalized major research and data analysis projects that were intended to address the main body of criticisms that were leveled against the RCCA, that being that penalties authorized under the Act were just supposedly too lenient. Now, we made clear in the past that the RCCA's penalties were fully consistent with current district sentencing norms, but the CCRC hadn't conducted comprehensive research on statutory maximums authorized in the 50 jurisdictions around the country, or data analysis on actual sentencing practices in other jurisdictions. So our research and data analysis projects, to sum it up, though, do demonstrate that both current district sentencing practices and the maximum sentences that were authorized under the RCCA are largely consistent with national norms. So really, this came down to two large research projects. So first, we completed a nationwide survey of statutory maximum penalties in all 50 states for robbery, armed robbery, carjacking, armed carjacking, burglary, and armed burglary. And this research required just meticulously reviewing both the criminal codes in the jurisdictions, relevant case law, and in some cases, even contacting practitioners in those jurisdictions, again, just because every state has its own arcane, complicated sentencing rules and maxima and penalty enhancements, et cetera. So that was really necessary to actually ascertain what the statutory maxims are across the country. So it was a pretty arduous and painstaking research effort. But again, the results demonstrate that the RCCA's penalties were largely consistent with national norms. Second, the CCRCL completed an enormous and really unprecedented analysis of national sentencing norms. So as I mentioned in our past, we really relied heavily on making sure that our sentencing recommendations were consistent with district sentencing norms, based on comprehensive data that we'd received from DC Superior Court. And as we noted before, even the lengthiest sentences imposed under current law are within the statutory maximas that were recommended under the RCCA. But we had not completed a sort of similar analysis of national sentencing norms. Based on our research, there is no publicly available comprehensive data on sentencing practices from across the nation available anywhere. So finding none, we decided to do this task onto ourselves, which was just an enormously time-consuming but extremely important task. So to produce this analysis, the CCRC relied on the National Corrections Reporting Program. It's a collection of state-level data on prison admissions and releases by year that's compiled by the Bureau of Justice Statistics, or BJS. So we obtained access to this data, which is held securely at the University of Michigan. And relying on this data that's collected by BGS, we've been successful in really completing an unprecedented analysis of sentencing and time served data from across the nation. So we've now produced hundreds of graphs and charts that include detailed sentencing information from across the country. And I do want to point out vitally, this analysis includes data not only on what the initial sentences that people received when they were sentenced in their case, but we also had actual prison and admission and release dates. So we're actually able to analyze the actual time served in other states. And this is really vital because unlike many states, of course, the district does not have a parole system, and we have generally very limited avenues for any kind of post-conviction sentence modification. So whereas a person who in the district receives a 10-year sentence, they may actually have to serve a full 10 years behind bars. In other states, somebody who receives a 10-year sentence actually may be eligible for parole 2, 3, 4, 5 years earlier. Just to illustrate the kind of analysis and data that we now have at our fingertips, so our analysis now allows for comparisons of the 95th percentile initial sentence, the 95th percentile actual amount of time served for armed robbery across nearly all the states. And we can look at those figures controlling for whether the defendant had prior convictions or not, or whether they had multiple convictions in their case. And this analysis really demonstrates both that there's this enormous diversity of sentencing practices across the states, and that in nearly all cases, the proposed maximum sentences that were included under the RCCA were really as long, or in almost all cases, longer than even the 95th percentile amount of time served for a given state. And we really think that this data is going to be extremely important, not just for code revision efforts, but really for any number of policy and sentencing related decisions that are made in the district. As I've said in the past, it's really hard in a vacuum to determine what an appropriate sentence is for a given crime. I mean, this is borne out by the data that we see just this enormous variety in the lengthiest sentences across states. And so having this clear set of data from national norms is really going to help anchor and inform a lot of these decisions going forward. Next, we continue to issue code revision reform recommendations. And so these included revisions related to animal cruelty offenses, several public corruption offenses, as well as applicable definitions, and a novel offense that would criminalize the non-consensual distribution of sexual images that are created using artificial intelligence. So these revisions would really significantly improve the clarity and completeness of the criminal code, while also addressing some significant gaps in liability. Just to give some quick examples. So under the public corruption cluster, for example, the revisions that we submitted would clarify an ambiguity under current law as to whether a public official who misuses non-public official information for personal gain, this is sort of analogous to insider trading by a public official, would clarify whether that kind of conduct is actually criminalized under our public corruption statutes or not. Currently, the law is unclear on this, and the revisions that we submitted would have made it very clear when that conduct actually tips into criminality. Also, the CCRC's proposed consensual distribution of false sexual imagery offense would address what we think is a significant gap in our current law. So currently, there's no criminal offense that directly and clearly criminalizes the distribution of nude or sexually explicit images or videos that are created using artificial intelligence without the consent of the person depicted. And with the rapid proliferation of more powerful and less costly artificial intelligence tools, we think that the risk of these types of misuses just continues to grow. And our recommendations would really ensure that the district's criminal code addresses this novel form of harmful conduct. I do want to note that although these revised offenses were drafted in the style of an offense that would be included within an RCCA, we still believe that holistic code revision is the optimal approach. But passing individual statutes or clusters of statutes really does still further our mission and the district's goal of improving the clarity and completeness of the criminal code. And in the past, we've worked with this committee to redraft specific provisions that were initially drafted as part of the RCCA to work as standalone offenses that can just be grafted onto the current code. And of course, we'd be happy to work with this committee in any way to enact any of these individual recommendations into law. And then lastly, we've continued to provide just testimony advice on pending pieces of legislation before the council. So dating back to the beginning of FY24, we provided formal testimony on the License Suspension Reform Amendment Act, on the Strengthening Traffic Enforcement Education and Responsibility, or STEER Amendment Act, on the Addressing Crime Through Target Interventions and Violence Enforcement Amendment Act, and the Addressing Crime Trends, or Act Now Amendment Act. And in addition, we've also provided, not in the form of formal testimony, but feedback to council members and their offices related to the Emergency Residential Tranquility Act. I know that your office worked on, as well as the School Teacher Administrator and Mental Health Professional Protection Temporary Amendment Act of 2024. And then finally, I'd just like to again reemphasize take this opportunity to reemphasize the significant and ongoing need for comprehensive modernization of our criminal code. And again, we recognize the significant risks of interference by the federal government in our future comprehensive code reform efforts, but none of that changes the fact that our code is still badly outdated and that district residents continue to endure a lack of basic quality governance that's granted to the vast majority of our fellow Americans across the country. So as we noted in prior hearings, district judges, litigants must continually grapple with these gross flaws in the current code, which includes costly and time-consuming litigation to resolve what should be simple issues of law that the RCCA or revised statutes could have resolved, often with a single line of text. We've talked about examples in the past, and this past year we've had just yet another one. The DCCA decided the case Cardozo v. United States. In that case, they were presented with this issue of whether interrupting a person's walk for a split second in a way that was incidental to the commission of a secondary crime constitutes kidnapping under current law. Now, under the RCCA, this very issue would, whether this split-second detention be sufficient for kidnapping is just clearly addressed by the text of the statute. But due to the ambiguity under current law, the DCCA actually had to review this issue twice. So first time this case came up, it was decided by a 3-judge panel who initially affirmed the conviction. And then second, the court reheard the case en banc with all judges sitting to review the case. And the en banc decision eventually then reversed the decision of that 3-judge panel. And as an en banc opinion was issued nearly 3 years after the initial panel decision was first published. And this kind of lengthy, multi-year litigation would have been completely unnecessary under a revised code. And we've seen this in the past. We just see this to continue, this sort of unnecessary usage of what are pretty scarce and valuable, vital court resources. And I do want to note, in a concurring opinion in this decision, Judge Easterly lamented that, and I quote her, "Yet again, this court is called upon to interpret an antiquated statute that does not clearly describe the conduct to be punished." And she wanted to state that this case demonstrates that the district still needs a new criminal code. And until one's enacted, judges will fill the breach to the extent we are able. But in a representative democracy, fundamental and elemental questions about the boundaries of criminal law and the appropriate punishment for its violation are best addressed in the first instance by the council of the district's legislative body. So just to conclude, of course, we echo Judge Easterly's statements about the dire need for an updated code. And while we understand that a comprehensive, holistic reform in one single bill may be a challenge in the short term, we're really deeply dedicated to continuing this process in the long run. And again, even if that means much more piecemeal changes in the shorter run, that can still make meaningful improvements to our code in the here and now. But thank you again, council member, for holding this hearing, and I'm happy to answer any questions that you may have.
Great. Thanks very much, Director Park, and thank you for that update and review. Starting with the kind of 50 state criminal code report, I know something that we talked about last year was this kind of need for a fulsome review that every jurisdiction in the country really could benefit from, and the federal government. Is that something that you had one person on staff, I think, who was focused on this report? Is that what she spent the last year focused on, pretty much?
That's right. And it was not only an immense amount of work, it was just a huge amount of perseverance. And again, this is detailed in the reports, but our initial research request, and we spelled this out very clearly, was to produce something really more akin to the data analysis that we did for district sentencing practices. I said this in the past, but the report that we did for district sentencing practices is extraordinarily detailed. So you can look up literally every single crime. You can look up the 5th percentile, the 10th, the 30th, the median, et cetera, et cetera. Controlling for various factors, controlling by race, controlling whether it was attempt or conspiracy or a completed offense, for a full decade. And we made it pretty clear that's the kind of analysis that we wanted nationwide, that level of granularity. And we actually did it. So our research scientist, Margaret Bronstein, completed that task. I mean, it was literally millions and millions of cells worth of Excel spreadsheets, just an immense amount of analysis. And again, this research project had been pre-approved. BJS and NACJD is the other organization that housed the data, and they need to approve this data for release. It's all on a secure remote server. At that point, they balked because, as a practical matter, the spreadsheet was just too large for them to analyze. It was, again, literally millions of cells. So you had to go back to the drawing board, and really a lot of creative thinking and collaborative work with NACJD and BJS. We're eventually able to get still an extraordinarily comprehensive amount of data, like I said, hundreds and hundreds of graphs and charts. It's not as comprehensive as what we had wanted, but we did get really the most important information, which is really sort of the lengthiest sentences imposed and the lengthiest amounts of time actually served across the nation, as well as a host of other pieces of information that are going to be highly valuable to us. So in other words, the process took longer than it ought to have, if there had been some more clarity from BJS up front. But it was an immense amount of work, and I really can't tell you how proud I am of really the fact that we were able to produce this unprecedented analysis, which I think is going to be highly influential, again, not just to our work, but even potentially to the Sentencing Commission and their kind of recommendations as they move forward, to actually have national data to help inform their decisions, as opposed to kind of flying blind the way that policymakers have, not just in the district, but across the country.
Right. And it always struck me, and this is something we talked about last year too, that this should be a national interest and something that there's federal funding for, especially since every other state can benefit from the research that DC has funded.
Yeah, I agree. And to agree, there is. I mean, it is the DOJ. BJS is a branch of DOJ who actually compiles the data and pays to have it housed at the University of Michigan. So there is this federal involvement, but yeah, no one is able to produce anything nearly as comprehensive as we have. But you said we have had conversations with them about pursuing something closer to the initial sort of multi-million cell spreadsheet that we'd first worked on. I think just have some reservations about that, again, due to some practical and political concerns on their end. But the work is already done. I mean, in a sense, all that would need to be done is them to review and approve it. But again, even what we have, I think, is going to be hugely valuable across the board.
Is the Tableau able to compare DC to the rest of the country, or is that in a different chart?
Yeah, so for now, it's not. So we were told there were issues in terms of reporting data through the district data through the BJ system, in part because we have this sort of bifurcated. We don't have, again, our own state-run prison system, essentially. And so whereas like the state of Georgia, they have all their data stored in-house, they could just provide that directly to the BGS system. So the Tableau system does not have the district data within there. That said, of course, we have our own Superior Court sentencing and time served data that we can rely upon. So we're in the process right now of, we published the Tableau results, but we're going to publish then a more detailed report, which will include not just the methodology of our analysis, but also exactly these kinds of comparisons. So we'll have a graph showing, say, armed robbery sentences and time served, and then we'll have a line there showing, well, this is the lengthiest sentences within the district according to district Superior Court data. And so you can make that kind of more apples to apples comparison.
Okay, and when can we expect that to be ready?
It may take a while because writing up the methodology is going to be lengthy. That said, we already have some documents that will, a graph where you could compare sort of national practices to the district. And so I'm certainly happy to share those with your staff if, upon request. I think I may have froze. Can you hear me, Councilmember? Sorry, I think we may have.
Yes, can you hear me?
Yes, I can. Yeah.
Oh,
Some technical issues there.
on
I'm not sure if my last answer made it through or not, but
So I cut off when I asked about how long we can expect that data to be up and running, and just at the beginning of that answer, I cut off.
sorry.
Sorry about that.
So I'm not sure necessarily this final report will take, just because writing up the methodology may be a little time consuming. We're also in the process of double checking some of BGS's data. So what often happens is states will report their sentences and their case information to BGS. BGS then makes its determination of, oh, this person was convicted of statute X in Kentucky. We think that's their theft statute, or we think that's their UUV statute. And that's how the data then gets categorized within BGS's data. So we've now been in a review of a handful of these, which seem a little bit irregular, to determine, did BGS really make the right kind of determination when they said, we think this statute, for example, is a UUV offense, to make sure that it's really comparable. And in some instances, we don't agree with their analysis. So we're doing some process of sort of cleaning up that data and really assessing whether it accurately reflects what we would consider, for example, a misdemeanor theft or UUV type conviction. So there's a little bit of cleanup at the back end. But I was going to say, though, that certainly, we'd be happy to share what we have, certainly in the interim, with any of your staff. I mean, we do have some graphs that are now completed where you can compare, say, the national norms on a given offense, and then quickly compare that to a dotted line that we would put in to illustrate where the district's lengthiest sentences are. So we can certainly share that on an ad hoc basis, even before final report is completed.
Got it. Okay, thank you so much. That would certainly be helpful, especially for some of our gun related offenses that I'm interested in. So part of your findings in the report were that there were significant differences between the actual sentencing practices of states versus what their statutory maxima on the books was, and that DC is similar in this regard. Did you find any pattern across the country as to how different the sentencing practices were from the states from that maximum? And how does that compare to what we have in DC?
So do you mean relationship between what the statutory maximas are and then what the actual
sentences are, right?
Yeah, no, so we do have statutory maximas for several offenses, like I talked about. That was a research project. We don't have them for every single offense that's included in our sentencing analysis. Again, it's an extremely time-consuming affair to sort of go through all these. Um, but no, at this point, we have not sort of said, yeah, are there correlations, for example, between, say, the armed robbery max in various states, and then how that lines up with those states' actual sentencing practices? Um, I'd be curious to know. That's exactly the kind of analysis that this sort of data opens up, that was not possible before without this sort of data. So it's something that we can certainly look into. And part of the benefit of having this data now is exactly this. If there are these kinds of research questions that the council or the Sentencing Commission or sort of anyone else has who works in the space, we can then sort of, after the fact, use the data analysis that we've done to sort of run that kind of research and analysis. Um, it's a great question. So I don't know what sort of correlations exist, if any, between the statutory max and then what the actual sentencing practices are. I wouldn't be surprised if there actually is not a particularly strong correlation, just because of how all over the map we see both maximums and sentencing norms. But I'm not really sure unless we do that analysis first.
Got it. Okay. Let's talk a little bit more about some of the other reports that you worked on. So for the non-consensual distribution of false sexual imagery, can you elaborate a little bit about what this is, why this is important, why you think it should be a new offense?
Sure. Yeah, so this is addressing what the common parlance has come to be called known as deepfakes. And so this is where someone uses artificial intelligence to then scrape lots of images and or video of someone off the internet. It could be social media, it could be publicly available photos, whatever. And then can use AI very simply to tell it, hey, create a very realistic looking, say, nude image of a particular person, or that person engaging in some kind of sexually explicit conduct. Um, it's totally novel behavior, of course, because only very recently has had AI tools that can actually convincingly and reliably and cheaply make this kind of material. And it's not really adequately addressed by current law. So arguably, there are certain statutes that could come into play. So if this is distributed widely enough on a recurring basis, it potentially could constitute electronic stalking. The closest fit might be what again, colloquially is to become known as revenge porn. So this is the non-consensual distribution, but really it has aimed at real photos that a person may have obtained in the course of their relationship with another person. Arguably, that one could cover it, but the statute, the way it's currently drafted, does appear to be aimed at authentic, genuine images or videos of a person. So we recommended really issuing a new novel offense to make it crystal clear that even inauthentic, artificially produced images or video, distribution of those without consent still constitutes an offense, because it's just a major gap. And we really felt like for some very minor reasons, it's better to have a standalone offense than simply to adjust the current revenge porn offense to tweak it to make sure that it covers artificially created sexual images. Some states have done that. It would be better than nothing. I think it is one avenue. But because these two offenses, while closely related, have some meaningful differences, and also we felt like there was some expressive value because it's such novel conduct in creating a totally new novel offense to make it absolutely crystal clear that this conduct is not acceptable. That's part of why we recommended having a new standalone offense as opposed to just sort of tweaking a current statute.
Okay. And are there any kind of litigation gaps that you foresee in this type of space? I'm just thinking back to when we tried to regulate around non-consensual kind of airdrop images that we were seeing happen in, public libraries or public transportation where people were sending private pictures of themselves without consent to other people at an open airdrop system. And there were some concerns that the language was too broad, or that it could be interpreted as criminalizing certain art, for instance. How are you thinking through some of those gaps if we went with a standalone offense in this space?
Yeah, so anytime you criminalize this sort of thing, there are going to be some potential free speech concerns. There is not, to our understanding, sort of clearly held decided case law on this. Again, because this conduct is just so novel, it's not as if someone's been prosecuted under this kind of new offense and then challenge their case up to the Supreme Court. I said, we included exceptions for really what would be fair use, like genuinely satirical purposes, things that no one would ever believe are actually real. If someone made a totally cartoonish, like, something that's obviously fake sort of an image, we try to say, okay, well, that's going to be omitted again as a, trying to make sure this is narrowly tailored as possible to respect free speech rights. That said, going back to a lot of the case law that does exist in the revenge porn context, which again hasn't made it to the Supreme Court, but a lot of some state Supreme Courts have taken this up. They have tended to hold that these offenses that criminalize revenge porn statutes are constitutional. And one of the things that makes them narrowly tailored is the fact that it requires that the person knows that they lack consent, the person depicted. Again, it's a little different, but we do think that, again, because one of the elements of this offense is that it requires intent so the person has to know that the person depicted it in the deep fake did not consent to this distribution, that it would similarly survive constitutional scrutiny. But to be fair, the law is somewhat
I'm so
unclear.
sorry, Director Park. I just need 1 minute. My alarm's go. 1 second. I'm so sorry. I'm so sorry about that. Please go ahead. You're
No
talking
problem.
about non-consensual.
Yeah, because I was saying, again, the Supreme Court doesn't have crystal clear case law on this yet. So, I mean, there is some ambiguity, but we really tried to draft this offense so that it would be narrowly tailored enough that it would be constitutional. And again, sort of piggybacking on some of the case law about revenge porn, that intent element or the knowledge element that the person lacks consent is often one sort of an important factor in upholding revenge porn statutes. And we think that it would be similarly upheld due to that knowledge/intent requirement that we would have under the AI deepfake version of the offense.
Got it. Okay. Have there been other jurisdictions that have adopted similar language?
Yeah, so I forget the exact count off the top of my head, but yeah, most jurisdictions have moved forward in some way or another to clarify that their criminal codes include and cover this kind of conduct, sort of non-consensual deepfake distribution conduct. So the district, yeah, at this point already is pretty behind the ball. And I know there is some movement also of a similar federal statute. So yeah, it is rapidly becoming the national norm to explicitly criminalize this kind of conduct in the district. It's still kind of playing catch up, but again, I think it's the kind of bill that could not overly complicated to move as a standalone piece of legislation. It's something that we could definitely work on in the short term.
Okay. And you mentioned a federal statute. Is it your sense that the federal government is considering their own kind of regulation in this space in the short term?
Yeah, I know there were some hearings during the past years about, and they were much broader. They're addressing a number of other wrongful AI uses. So I'm not sure the exact scope of what the federal government might want to tackle. There are at least two other broad categories of misuses of AI that we chose not to address. And so one that did come up at the federal hearing is essentially using AI to trick someone into thinking that there's a hostage situation. So this is AI is used to very realistically mimic a family member's voice. And they say, I'm being held hostage, send money. The other category is for just sort of political misinformation. I mean, this even occurred during the last presidential election, where I think someone used AI to create a fake voice of Joe Biden calling voters in New Hampshire. We determined that in our analysis that those two classes of conduct, while significant, are really better addressed through other areas of law. And so just ordinary fraud and extortion offenses would cover the kind of misuses of, tricking someone into thinking that someone's being held hostage. That's extortion. And as far as political misinformation, that really starts to run afoul of First Amendment issues. We start criminalizing speech that's false in the political context. And so our view is, in the time being, just due to the extreme First Amendment concerns, and the fact that, to be frank, misinformation and some degree of dishonesty in political discourse is nothing new. And so politicians over the years, really 200 centuries, have dealt with this, with people mudslinging at them. For now, until it seems the problem becomes more pronounced, our recommendation was just to sort of leave that alone within the purely political sphere, in the way that we do other manners of sort of false speech in the political space. So we took a little bit of more of a narrower tack here, but really to focus in on the sort of sexualized deepfake uses. And that is the consensus. I think most states across the country are really focusing very much on addressing that gap in their codes.
Okay, thank you for that context. That's helpful. Can you elaborate a little bit on the public corruption offenses, kind of what problem you're seeking to address and how you think this would be implemented here?
Sure. Again, I think what I mentioned is a lot of the big benefits of the current law is quite unclear. So much like a handful of statutes will do this, but they'll refer to, bribery is just giving money to a public official corruptly in order for them to commit some kind of public act. And that word corruptly, it does some work. I mean, it's sort of, maybe you know it when you see it, but it's really not sufficiently clear. And there's just lots of areas of conduct that I think most people would agree are corrupt and are wrongful. And it's not clear whether or not it's captured under our current bribery statutes. So I mentioned the one example in my just oral remarks. This is kind of like the sort of form of insider trading. So this could be, as a government official, I know that a plot of land is about to be rezoned in a way that increases its commercial value. Before that public information goes public, I or a family member or someone like that snaps up the land and profits off of it. Again, that seems sort of like a misuse of information, not something that public officials ought to be doing. And the revisions that we recommended would really clarify the scope of exactly when that kind of conduct is criminalized. Another example is what's known as gratuities. So the standard bribery involves a quid pro quo, right? So I'm going to give this public official some money, and in exchange, that official will then perform some public act, right? They'll vote for legislation, they'll issue an amendment, whatever it might be. There's a case that went to the Supreme Court a year or two ago, and it was about an after-the-fact gratuity. So a public official did something that was highly beneficial to one of their constituents, financially beneficial, and that person went and gave a very large cash payment to that public official, just as a way of saying thanks. Again, this would generally run afoul of certain ethics laws, but it's very unclear whether or not that violates the district's bribery statutes. Just as it was unclear whether that kind of conduct violates the federal bribery statutes. And again, that cases go all the way to the Supreme Court for them to grapple with. That's the kind of policy determination that we should be really making before the fact. And so we recommend in language that would clarify exactly when or when not those kinds of gratuities would constitute public corruption. So there's a lot of gaps like that we're really seeking to address, and that we think that the recommendations we issue will really help clarify that scope of what public officials can and cannot do, and when their conduct actually trips over to the territory that we would deem criminal.
And who would you have regulate that action?
I mean, this will still be prosecuted through the U.S. Attorney's Office as just a criminal offense.
Got it. Okay.
Yeah.
And then in terms of other projects that you are working on, how are you prioritizing kind of the areas that you're focused on next? And are there any substantive topics that are going to be kind of your area of focus in the next couple of months?
Yeah, I mean, so part of it's sort of a combination of sort of what's doable given personnel restraints, and also just what we deemed to be more important. So for example, we're coming very close to issuing some new recommendations on anti-dumping offenses. Part of why I want to do this was always on the to-do. Part of why we really bumped it up is because there was this spate of dumping, of people dumping tires. I believe also the AG had some issues with some company in the district that was polluting, sending chemicals out improperly. So when like stories like that hit, it sort of like bumps. Okay, we got to make sure we're really reviewing the anti-dumping legislation. And so yeah, it's sort of what's doable. It's a combination of what's doable, where we have the most impact given our resource constraints. So we're expecting shortly to have recommendations on anti-dumping, recommendations related to private corruption. So you just talk about a lot of public corruption offenses. It's a whole separate area of what a similar related offenses, but a private actor. So this might be something like, instead of bribing a public official, bribing like an auditor who's coming to, right? He's a private actor, but has this almost quasi-judicial function, sort of a position of trust that people are supposed to be able to rely on their findings. So we're going to be issuing a recommendation related to that. And then as well is a change to evidentiary law, a recommendation of a change to evidentiary law in the district, related to when people can introduce evidence of their mental incapacity to show that they lacked a requisite mental state. Part of why this is just important, we're a stark outlier in this regard. It creates a significant potential of wrongful convictions. It's a change to law that can be made with a relatively small amount of textual statutory text. And so it seemed like a really meaningful, but again, sort of more relatively bite-sized piece of legislation that could be handled regardless of what happens with the larger code. It doesn't need to be a part of a holistic revision. Can be, and it should be, but it also works as standalone legislation. So that's kind of things that we expect sort of in the near medium term of this fiscal year.
Got it. Okay, well, thank you. That concludes my questions for you today. As always, I want to give you a chance if you want to highlight something we didn't get a chance to talk about, or if you have any closing thoughts.
Yeah, it's just, again, I know everyone that this is just a tough climate for reforming these matters. But I still really think that the council and this committee and certainly our agency can work together to make, even if it's just piecemeal changes over the course of this year. I think we can make really, really meaningful improvements to the code, or over this whole council period, rather. It's really more the normal work that I kind of envisioned the CCRC doing. I mean, the RCCA was so huge, it's sort of easy to forget. And we spent so much time on it, it's sort of easy to forget that that's not normal. The regular churn is sort of much smaller piecemeal improvements. That's sort of what I know, the kind of legislation that's moved through here, your predecessors have done that in the past. And I think we can continue to do that and just continue to make really, really meaningful changes. Even if it's not as big as what, I had dreamed of. I still think that there's a lot of just really, really valuable work that we can do, even without having a full-blown RCCA version 2 in the short term. Though again, we certainly hope, and I'm happy to have conversations in the future about how we can move forward with that, even if it's on sort of a piece-by-piece, chunk-by-chunk basis. I do think it's doable. Even if not today, it will be doable in the not too distant future.
Well, thank you very much, Director. Thank you to you and your team. Please send everyone my best, and thank them for all of their hard work over the past year. And the time is now 11:10 a.m.